Good morning. We are Marta Fuente, Mariano Cito, and Alicia Muñoz, and we are going to talk about the gender pay gap. We are going to make a brief summary of the history of women in the labor market, then about the economic aspects, the legal aspects, and finally the conclusion that we made. The reason why we chose this topic are because this year marks 25 years since the adoption of the United Nations Peking Declaration, aimed at the advancement of women around the globe. 5 years since the adoption of the Sustainable Development Goals, which one of these goals is especially focused on the gender equality, and because we are women. So, progress has been for sure made. Changes in the last 100 years have been radical. Throughout history, women have always been given a traditional role in the home, doing housework, cooking, and cleaning. In the late 18th century, with the Industrial Revolution, women began to enter in the labor market. However, they didn't have the same conditions. They were paid less than men and didn't have the same labor rights. The fight for equality in the labor world was one of the reasons that gave rise to Women's Day. At the beginning of the 19th century, the International Conference of Socialist Women claimed the right to vote for women, while factory workers in the United States went on strike to achieve job improvements. In the middle of the last century, more and more women were working in factories, mainly because of warfare. During the First and Second World War, men went to fight on the battlefield and women replaced them in factories so as not to lose production. The famous We Can Do It poster was created in the United States during World War II to raise the spirits of the population. Women played a key role in keeping the country moving. They took men's place in factories and kept the economy from collapsing, but equally they continue to have working conditions far below men's. Nowadays, inequality between men and women persists. That is why changes still have to be made. We wanted to talk about the difference in society between men and women. However, we needed to focus on a more particular topic, at least if we didn't want to speak for days.
So, we also wanted to see this problem for a more economical point of view. Gender inequality is a pervasive feature in many developing countries. The gaps between male and female outcomes and opportunities are present in several dimensions: education, earnings, occupation, access to formal employment, access to managerial positions, access to productive inputs, political representation, or bargaining power inside the household. These gaps are particularly dramatic in developing countries, where ideologically they are less advanced on gender equality. It is in developing countries where most inequalities happen regarding the protection of women, too. Moreover, women are also underrepresented among top positions in most countries, but not only in developing countries, but also in the most developed ones. In 2018, while women represented 39 of the world's employment, only 27 of managerial positions in the world were occupied by women, up from 26% in 2015, meaning that in 3 years, this amount only grew 1%. The good news is that the proportion of women in management has increased since the year 2000 in all regions, except for the least developed countries. We thought that one of the most reliable data to show the different way of behavior towards women resides in the labor market. On average, women are paid less than men, and this is what we call the gender pay gap. The gender pay gap or gender wage gap is the average difference between the remuneration for men and women who are working. For us, as women who are currently studying to get a job in our near future and also who want to succeed, this really does directly affect us. And it is why we are really concerned to really be able to understand this and be able to fight it. This is obviously a global issue, but as we're from Spain, we selected two data that really, caught like our attention, and we tried to be more specific by, selecting the data from our country. On average, in 2017 in Spain, women that have a job gained 20,607.85 years annually, which is more or less 6,000 years less than men, who received, on average, 26,391.84 euros. In addition, the gender wage gap in Spain was 21.99% in 2017. Regarding the pay gap, there are two distinct numbers: an adjusted versus adjusted pay gap. On the one hand, the unadjusted gender pay gap is defined as the difference between the average gross hourly earnings of men and women expressed as a percentage of the average gross hourly earnings of men. On the other hand, the adjusted pay gap usually takes into account some factors that impact these gaps' existence, such as differences in education, job existence, job sector, job position, number of hours worked, marital status, parenthood status, etc. The adjusted pay is substantially smaller than the unadjusted pay gap, as the adjusted pay gap thus measures only overt workplace discrimination against women workers. This has led many conservative and libertarians to denounce sexism being a factor behind the pay gap. Some of the reasons of this gap, more from a more social point of view, are discrimination, childcare and family responsibilities, health insurance in the US, for example, undervaluing of women's work and skills, educational and career choices, the amount of work, and systematic non discriminatory bias. As business and economics students, we asked ourselves what economic benefits or reasons you might have to be discriminative with your employees' salaries. These are the two main theories that try to explain this. On the one hand, we have the neoclassical model, which believes that by excluding or limiting employment of a specific group, you will raise the wages of groups not facing this discrimination. Other firms, then, could gain a competitive advantage by hiring more workers from the group facing that discrimination. As a result, in the long run, discrimination would not occur. However, this view depends on really strong assumptions about the labor market and the production functions of the firms attempting to discriminate. Firms which do discriminate on the basis of real or perceived customer or employee preferences would also not necessarily see discrimination disappear in the long run, either under stylized models. Then we have the monopsony explanation, which describes situations where there is only one buyer. In this case, it would be a buyer for labor. Wage discrimination can be explained by variations in labor mobility constraints between workers. Women appear to be less pay sensitive than men, and therefore employers take advantage of this and discriminate in their pay for women workers.
Over the past 25 years, there has been progress in reforming laws towards improving gender equality. Yet discriminatory laws and gaps in legal protection remain in many countries. Our aim is to help reduce the often blurred discussion about the gender pay gap to its essence, and to reflect on the question of how law and legal instruments may help close the gap. Most of the experts seem to agree that the gender pay gap is primarily a socioeconomic problem that will by no means be resolved by legal rules only. However, the experts do conceive a role to be played by the law, primarily by providing a framework for all the actors involved. Indeed, by explicitly prohibiting direct and indirect pay discrimination and enforcing this prohibition effectively, and by imposing obligations concerning equal pay, law may be a useful tool. Such legal framework already exists, and in the view of many experts, it is capable as such of being used to address the issue of pay discrimination. In certain aspects and in certain countries, the legal framework might be further reinforced. The community law principle of equal pay is in general well implemented in national legislation. It is often safeguarded at both constitutional and legislative level, either as a part of general labor law or as a provision in a specific anti-discrimination legislation. As a rule, both direct and indirect discrimination are explicitly covered. Similarly, the requirement of equal pay for equal work or work of equal value is often laid down in the law. The main problem with law is not so much what it states at the abstract level, but rather how it is put in practice. That means that there is a problem in detecting the discriminations and in effectively enforcing the equal pay rules. In other terms, there is another gap, one between the law in the books and law in everyday reality. The difficulty derives from the complexity and multidimensionality of the phenomenon. On the basis of data collected across 4 areas of law, in 218 from 53 countries, almost a third have legal gaps in the area of general legal frameworks and public life, that is, constitutions, anti-discrimination laws, quotas, legal aid. More than a quarter have legal gaps in the area of violence against women, and 29% and 24% have legal gaps in the employment and economic benefits area and in the marriage and family area, respectively. In most European countries, collective bargaining and the resulting collective agreements are an important source of labor law, of rights and obligations in the employment relationship. Although the specific legislation on equality does not contemplate specific regulations on equal remuneration, it does establish the obligation to implement equality plans in companies and the general guidelines for action. This must be specified in the framework of collective bargaining. Some of the standards incorporated in the agreements relate to the women's access to sectors and occupations in which they are underrepresented, indefinite hiring, gender-neutral selection, classification, promotion and training systems, an organization of the workday that allows a better reconciliation of family and work, and equal remuneration. However, the incorporation of clauses is of limited character, often alluded to the lack of representation of women at the negotiating tables. Legislative measures in this area have been taking place for years in international organizations and among the governments of many states. The International Labour Organization or the European Union have contemplated the principle of equal pay, both in their fundamental treaties and through various directives and binding acts. With the Treaty of Rome in 1957, the European Union explicitly considered the principle of equal remuneration between women and men, providing the basis for the implementation of different important European measures in this regard. Some of the different treaties and directives that have been introduced.
As a conclusion, it is evident that the law is not enough to reduce the pay gap between women and men. Government initiatives go beyond legislative mechanisms and include the creation of institutional mechanisms, adoption of action plans, and so on. Despite the rather limited effectiveness of measures aiming to reduce the gender pay gap, the following can be identified as relevant proposals for social dialogue on labor participation of women and promotion of equality between men and women. the establishment of legal plans of equality that can serve as minimum standards during collective bargaining. Another element is the establishment of neutral systems of selection, classification, promotion, and training based on technical and objective criteria. And lastly, the implementation of legal and conventional measures to ensure full transparency in the salary structure. If the final objective is to put an end to salary differences between men and women, which makes this as a consequence of the inadequate application of the principle of equal pay, a change in the actual legislation concerning this matter would be necessary. The possibility of reforming collective bargaining terms through the future Act on Equality between Men and Women has been discussed in specialized forums, and it entails the creation of a program to eradicate the gender gap through certain measures as compulsory presentation of information by all social agents, which entails that all official agencies collect information and statistic data disaggregated by sex. Annual assessment of the application of collective clauses by a specialized commission in matters of equal pay, and corrective measures for the accomplishment of the objectives and the existence of adequate sanctions for existing discriminations. And to finish with our presentation, as Carolina Herrera said, the impossible does not exist for a woman. It only takes longer to get. Thank you.